going on? Emina 36 na legislature in Guam is now called to order. Good morning, colleagues. Majority Leader Senator Nelson, you are recognized. Oh, I'm sorry. We're going. Yeah, I'm sorry. My apologies. We'll begin with a prayer. Good morning. For the prayer, Senator Perez, you are recognized. Would you kindly lead us in prayer?
Ginaani Tata, Dani Lahinia, Dani Espiritu Santos. As we open this session in the heart of the Fanutsanan season, let us remember our Manaina, those that have come before us. Let us remember their courage, their perseverance, their resiliency, and their will, so that our people would inherit a legacy of over 3,500 years of endurance in the islands of the Marianas Archipelago. Let their stewardship of our island stand as an example to guide our actions in this session and sessions to come. Let us reflect on what kind of ancestors we seek to become and hope to achieve an effort worthy of guidance to our future generations. For your sacrifice, we express a never-ending and never-forgotten gratitude from the people. May we draw the love and strength needed to make sacrifices of our own in order to nourish the community for which we gather. Ginaan I mananaitan mami, igagagaw I minet gumizu, parata chogwi hafa I manalak paritautauta. In the name of our ancestors, we ask your strength to do what is good for our people. Ginaan I Tata, Dani Lahinia, Dani Espiritu Santos. Amen.
To express a never-ending and never-forgotten gratitude by the people of Guam, the legislature recognizes recipients of Imaladan Mastakilu na Sacrificio on a display in the Guam Congress building and during each of its sessions. For the recognition of the recipient of Imaladan Mastakilu na Sacrificio today, Senator Taitagui, you are recognized.
Sidus Masi. On behalf of a grateful island and country, we honor Staff Sergeant Joaquin Palacios Cabrera and the family of Staff Sergeant Joaquin Palacios Cabrera for making the ultimate sacrifice in service and defense for our island and country.
For the recitation of Inifresi, will Senator Terlahi kindly lead us?
Thank you, Madam Speaker. Good evening, Mastakilo Gihinasoko. I Mastatkalum Gikarason. Tani mas figo na ni nasinyahu, kufration maisazo, para be putei, and the Yenengi, Kultura, Ilingwahi, Airi, Hanum, Danitano tomorrow. Near in Shaku, Ginin Azu Stata, Estiu, Ufetman Hilo Ibibda, Dani Bandiraho, Bandirangwam.
For the singing of the Guam hymn and the national anthem, would Senator Blas kindly lead us in the singing of the Guam hymn, and Senator Ada in the singing of the national anthem?
Fanogita moru
Purita nota, kantai matuna yagitodu ilugar. Para I honra, para I gloria, abiba islas en para. Para I honra, para I gloria, abiba islas en para. Todo I tempo I paz para hita, zangin I langit na bendición. Contra peligro na fansafuham, Zeus protegis languam. Contra peligro na fansafuham, Zeus protect his
land Guam.
Can you see by the dawn holy light what so proudly we hailed at the twilight last gleaming, whose broad stripes and bright stars through the perilous fight all the ramparts we watched were so gallantly streaming, and the rockets' red glare, the bombs bursting in air, gave proof to the night that our flag was still there. Oh, say does the stars-spangled banner yet wave o'er the land of the free and the home of the brave?
Si Diyos masik. Please be seated. Madam Clerk, please take the roll call.
Senator Atta, Senator Blas, Senator Brown, Senator Duenas, Senator Moylan, Vice Speaker Munya Barnes, Senator Nelson, Senator Perez, Senator Rangel, Senator San Augustine, Senator Shelton, Senator Taitagui, Senator Terlahi, Speaker Terlahi, Senator Torres. Madam Speaker, there is a quorum.
Thank you, Madam Clerk. Majority Leader, Senator Nelson, you are recognized.
Sijus Masi, Madam Speaker. I move to approve the Legislative Journal dated September 23, 2022, subject to corrections.
On that motion to approve the Legislative Journal, are there any objections? Seeing no objection, motion carries. Majority Leader, Senator Nelson, you are recognized.
Sijus Masi, Madam Speaker, there are communications and petitions, and I move that they be appended to today's session journal.
On that motion to append communications and petitions, are there any objections? Seeing no objection, motion carries. Senator Nelson, Majority Leader, you are recognized.
Madam Speaker, there are messages from Imagahagan Guahan, and I move that they be appended to today's session journal.
On that motion, that messages from Imagahagan Guahan be appended to today's session journal, are there any objections? Seeing no objection, motion carries. Majority Leader, Senator Nelson, you are recognized.
There are reports of standing committees, and I move that they be appended to today's session journal.
On the motion that reports of standing committees be appended to today's session journal, are there any objections? Seeing no objection, motion carries. Majority Leader, Senator Nelson, you are recognized.
Sijus Masi, Speaker, there are no reports of select committees.
Thank you.
Proceed.
Please proceed.
Madam Speaker, I move that bills introduced, bills number 335-36 COR through 338-36 COR and 339-36 LS through 342-36 LS, and resolutions introduced, resolution numbers 432-36 COR through 436-36 COR, 437-36 LS through 448-36 LS, and 449-36 COR through 453-36 COR be deemed to have been given their first reading.
On that motion, as to the introduction and first reading of bills and resolutions, are there any objections? Seeing no objection, motion carries. We're now in motions. Majority Leader, Senator Nelson, you are recognized.
Madam Speaker, I move to excuse senators not present for today's legislative session.
On that motion, is there any objection? Seeing no objection, motion carries. Majority Leader, Senator Nelson, you are recognized.
Madam Speaker, I move that all congratulatory, commendatory, and condolence resolutions introduced today and for the remainder of the legislative session be considered first read and adopted to allow the Legislative Council to make technical corrections and to add all senators as co-sponsors.
On that motion, are there any objections?
Objection.
Seeing no objection, motion carries. We're still on motions. Are there any other motions? Senator Taitzagui, you are recognized.
Madam Speaker, and good morning to my colleagues. Madam Speaker, I motion to place Veto Bill 293-36 in the voting file. Notwithstanding the objections of Imakahaguahan, I again move to place this and speak on it. Respectfully ask to speak on it.
Senator, you said Bill 293. Do you mean 239?
239-36, sorry.
On that motion, please, you may discuss the motion.
Thank you, Madam Speaker. Madam Speaker, vetoed Bill 239-36 COR, an act to add a new Section 76206 to Article 2 of Chapter 76, Division 3, Title 11, Guam Code Annotated, and to add a new 13510 to Article 5 of Chapter 13, Title 19, Guam Code Annotated, relative to the business license requirements for entities engaging in child placement services. Vetoed Bill 239-36 is sponsored by myself, Madam Speaker, and co-sponsored by Senator Brown, Speaker Therese Terlahi, and Senator Sabina F. Paris. Madam Speaker, I offer this latest override motion and ask the support of my colleagues in approving Bill 239-36 COR, notwithstanding the objections of Adelup. Madam Speaker, both the submission of draft intern licensing rules and regulations for private adoption companies are required by Public Law 36-68, and the possible adoption of these draft rules, recognizing Bill 334-36 is a potential item for this month's session, do not set aside the need for this legislature to override Bill 239-36. Madam Speaker, Guam does not have interim or any other duly adopted set of rules in place right now. Overriding Veto Bill 239-36 COR will ensure that once a set of draft or permanent license rules and regulations are adopted, Guam will have already established in law a clear and critical business license review process and partnership between Revenue Tax and Department of Public Health. Madam Speaker, I urge my colleagues to look beyond the personalities and the policies that have somehow managed to drive the conversations and the policy decisions on this public safety issue for almost an entire legislative term. I urge my colleagues to finally put the safety, health, and welfare of our most vulnerable children front and center, and so that we can finally put in place the administrative guardrails that are proposed in Vetoed Bill 239-36 COR. Sidus Masi, Madam Speaker.
Sidus Masi, Senator. On that motion, is there anyone who would like to be recognized on that motion? Senator Brown, you are recognized.
Thank you very much, Madam Speaker. You know, here we are another month into session. I guess maybe there's only a couple more left, as we only have 2 more months left in this term. And I'm not going to belabor it, but I will say it's unfortunate for this legislature that we continue because of, personality and political interests and alignments. That something is really almost, you would think, standard and otherwise would not be a big issue of discussion, continues to fail being overridden by this legislature. The simple requirement of having any agency or entity that wants to engage in the adoption of our children to have a process and procedure of acquiring a business license, and concurrence by the Department of Public Health that, under our laws have been designated as the agency that is going to oversee this process. How unfortunate. But colleagues, it's okay. please, vote no. Just like Bill 11, vote no. Keep voting no. Because, the people in their own way have their way of dealing with that. Maybe they're not happy with the way the legislature or the current, I sure as heck was, and I'm frank about that, Madam Speaker, why I'm here, why I ran again for this term, is because of this kind of stubbornness that really doesn't prioritize the policies that we're supposed to be here making in the interest of our people. But boy, when it's in the interest of others, wow, we're right there. We're right there to align ourselves with the administration when it's convenient, because of some of us, of our own connections. But when it's prioritizing the people, unless it's to make us look good, oh, we don't do that because it's not the right person sponsoring the bill. And yet we go before the people and ask them to support us and put us here and elect us to office. And yet, are they really our priority? This is one example of where they're not. And we know where the alignments are. We can count them on our fingers. That's why this bill hasn't been overridden, just like Bill 11 doesn't get overridden. Because we don't prioritize our people. At least some members of this legislature. Right now, the majority, but you know what? That always changes. Right now, that's in the hands of the people if they're happy with this kind of leadership direction that they're seeing. The in alignment and the out alignment. And I feel for Senator Tidigu. I'm sure I'm on that boat with her, but that's okay. I like being on the out boat. So colleagues, please vote no. I shouldn't be asking you to vote. Please continue to vote no on this override and show the people your true colors and who and what you truly are and why you're really here. Because when it comes to voting in the interest of our people on something really that others would think would be an innocuous piece of legislation that should be standard, like I said, I have to make sure the person that if I go to a beauty salon is doing my hair or my nails, gosh, they have to be properly licensed, but oh no, we won't put those requirements in place with regards to the adoption of our children. Our children, Madam Speaker, that we read every day in the paper are being harmed, are being abused, especially sexually in this community. And yet we just, let's go through the motions. But please do go through the motions because you know what, my dear colleagues, I'll anticipate that as a positive direction because I think people out there, the good people of Guam, that in many occasions, they surprise us. They actually do the right thing, what they know is the right thing for them. And vote for the people that they believe are standing up for them. And maybe those that are not, maybe they just don't get that support this time around. And we've seen it. We've seen people come in very high in an election, and my goodness, they just make the wrong mistake and they're out, or they drop, or the majorities change. Because I'm fairly confident, whether I'm in the next legislature or not, Madam Speaker, I'm fairly confident with some of the new players coming in, new members of this legislature.
Please state your point of order.
Madam Speaker, we're discussing the override for the veto that is being proposed.
Yes, we are,
This
Madam
is not
Speaker. That is
germane
what we're
she's talking
discussing,
about.
Madam Speaker, and I'm discussing the root reason that I, as a member of this
Senator
body...
Brown, I have recognized Senator Nelson on a point of order. You are now recognized to continue your
Oh, thank you,
debate.
Madam Speaker. That's very kind of you. How gracious. How gracious. Thank you.
It's the rules, Senator.
I appreciate the rules, Madam Speaker.
So
I've
do you
had a
want to
long
proceed
time.
or not, Senator?
Well, I mean, when I continue to be interjected,
Well, if you want to proceed,
this is my
this is your
perspective
time.
on why this bill's not overridden. There's nothing in the rules that say I'm limited in what, I'm constantly amazed at the desire to want to cut me off. I got the right to say what I want to say and how I interpret what I interpret on the floor of this legislature, just like anybody else. Whether you like it or not, you think I'm talking to you, that's up to you. I'm really talking to the people of Guam out there. And it's really sad. It's really sad that in this particular case, I'm sure Senator Tello will get up next month in the last one of the session once again to request that this bill be overridden. I hope she in the next legislature reintroduces it. I'm probably fairly confident it'll get passed and there'll be other reasonable minds there that want to do the right thing. Because boy, this is the time for us to stand up and be counted. So with that, I rise in support, Madam Speaker, and hopefully I can get through the rest of the session without constantly being interrupted. With that, thank you for the opportunity to comment on this bill.
Are there any other members who would like to be recognized on the motion?
Madam Speaker, I just rise in a point of order.
Please state your point of order.
Thank you, Madam Speaker. In our legislative rules on page 10, when it talks about session debate, debate is confined. Debate must be confined to the question before the body and debate on a bill is confined to the bill under consideration and does not extend to criticism of other bills before a legislator in Guam or in committee, even though they relate to the same subject. And so, Madam Speaker, I would just like some professionalism and collegiality within our body where we can speak on the bill instead of standing here and going off into tangents and digressing in a threatening language towards the rest of our colleagues. Thank you, Madam Speaker.
Thank you. Point is noted. On the motion, is there anyone who'd like to be recognized on the motion? If not, Senator Taitagui, you may close on the motion.
Thank you, Madam Speaker. You know, I appreciate the comments that are being made, and I'm going to continue to fight for this. I think we should all be fighting for our children, those who are most vulnerable, that need this, not only guidance, but put safety in place for them. And right now, there is nothing out there to protect our children. Let's not forget what happened in Marlboro. We don't want this to happen on Guam, or let's be proactive. This is about being proactive. Let's not wait till something like this, something terrible happens to one of our children because we didn't have rules and regulations in place and provide a mechanism, a process to ensure that whoever is going to open an adoption agency is vetted. It is vetted by public health. So let's be responsible, please. Thank you, Madam Speaker.
Thank you, Senator. On the motion, so there's a motion to place veto bill number 239-36 COR in the voting file, notwithstanding the objections of the governor. Is there any objection? Is there an objection? There's an objection. So on that motion, all in favor, please raise your hand. Motion passes. We're still on motions. Is there any other motion? Senator Perez, you are recognized.
Thank you, Madam Speaker. I move to place the nomination of Dr. Teresa Damian Borja to serve as a member of the Guam Memorial Hospital Authority Board of Trustees onto the session agenda.
On that motion, to place a nomination of Dr. Teresa Damian Borja onto the session agenda, is there any objections? Seeing no objection, motion carries. Senator Muñoz-Barnes, you are Vice Speaker Muñoz-Barnes, you are recognized.
Not yet done.
Sorry, Senator Perez, you are recognized.
Thank you, Madam Speaker. I move to place the nomination of William West Cassidy to serve as a member of the Guam Banking and Insurance Board onto the session agenda.
On that motion to place a nomination of William West Cassidy onto the session agenda, is there any objection? Seeing no objection, motion carries. Senator Perez, you are recognized.
Thank you, Madam Speaker. I move to place the nomination of John McKinnon to serve as a member of the Guam Banking and Insurance Board onto the session agenda.
On the motion to place the nomination of John McKinnon onto the session agenda, is there any objection? Seeing no objection, motion carries. Senator Perez, you are recognized.
Thank you, Madam Speaker. I move to place the nomination of Danilo M. Rapadas to serve as a member of the Guam Banking and Insurance Board onto the session agenda.
On the motion to place a nomination of Danilo M. Rapadas onto the session agenda, is there any objection? Seeing no objection, motion carries. Under motions, Vice Speaker, you are recognized.
Thank you, Madam Speaker. Madam Speaker, I move this on behalf of the Legislative Secretary, which is Bill number 257-36 LS, which is an act to increase the cost of living allowance payments for Government of Guam retirees and appropriate $15,945,600 from the general fund to the Department of Administration for fiscal year 2023.
All right, it shows that that has cleared on October 20th, 2022. So on that motion, to place bill number 257-36 LS onto the session agenda, is there any objection? Seeing no objection, motion carries. We're still on motions. Is there anyone else who'd like to be recognized on a motion? Senator Rangel, you are recognized.
Thank you, Madam Speaker. I move to place Bill number 306-36 COR as amended by the Committee on Economic Development, Agriculture, Power, and Energy Utilities and the Arts to the session agenda.
Thank you, Senator. That motion shows that the bill was placed up on the website on October 20th, 2022. On the motion to place Bill number 306-36 COR onto the session agenda, is there any objection? The title, could you
Sure, I
please read the
apologize.
title?
Bill number 306-36 COR as amended by the Committee on Economic Development, Agriculture, Power, and Energy Utilities and the Arts, an act to amend subsection 58104K and 58136 of Article 1 and to add a new Article 3 to Chapter 58 of Title 12, Guam Code Annotated, relative to the issuance of qualifying certificates to captive insurance companies who wholly underwrite insurance risks outside of Guam.
On that motion, is there any objection? Seeing no objection, motion carries. Senator Rangel, you are still recognized.
Thank you, Madam Speaker. I move to place Bill number 340-36 onto the session agenda, an act to amend Section 13 of Part 3 of Chapter 2 of Public Law 36-107, the fiscal year 2023 budget law relative to the University of Guam Capital Improvements Fund.
That bill was also uploaded on October 20th, 2022. On that motion, it's 340-36 LS. So on that motion, is there any objection? Is there an objection? Sure.
Madam Speaker, just to confirm.
Senator Nelson, you're recognized.
Thank you, Madam Speaker. Just to confirm that this was one of the prospective bills that was announced. Okay.
Yes, it was, and it was uploaded on October 20th. Thank you for that question. So on the motion of Senator Rangel to place Bill number 340-36 LS onto the agenda, is there any objection? Seeing no objection, motion carries. On motions, is there any other motion? All right. We're now on legislative concurrences. Majority Leader Senator Nelson, you are recognized. Senator Perez, you are recognized.
Tuzmasi, Madam Speaker, I move to place in the voting file from the Committee on Health, Land, Justice, and Culture the nomination of Dr. Teresa Damian Borja to serve as a member of the Guam Memorial Hospital Authority Board of Trustees with the recommendation to do confirm.
On the motion to place on the voting file, is there any objection? Seeing no objection, motion carries. Senator Perez, you are recognized.
Thank you, Madam Speaker. I move to place in the voting file from the Committee on Environment, Revenue and Taxation, Labor Procurement, Statistics, Research, and Planning the nomination of William West Cassidy to serve as a member of the Guam Banking and Insurance Board with the recommendation to do confirm.
On that motion to place that nomination on the voting file, is there any objection? Seeing no objection, motion carries. Senator Perez, you are recognized.
Thank you. I move to place in the voting file from the Committee on Environment, Revenue and Taxation, Labor Procurement, Statistics, Research, and Planning the nomination of John McKinnon to serve as a member of the Guam Banking and Insurance Board with a recommendation to do confirm.
On that motion to place the nomination onto the voting file, is there any objection? Seeing no objection, motion carries. Senator Perez, you are recognized.
Thank you, Madam Speaker. I move to place in the voting file from the Committee on Environment, Revenue and Taxation, Labor Procurement, Statistics, Research, and Planning the nomination of Danilo M. Rapadas to serve as a member of the Guam Banking and Insurance Board with a recommendation to do confirm.
On that motion to place a nomination onto the voting file, is there any objection? Seeing no objection, motion carries. We've exhausted legislative concurrences. There's no item on the consent calendar, so we are now on second reading. Vice Speaker.
At this time, colleagues, I will address Speaker Therese M. Talahi on Bill Number 248-36CR. Speaker Talahi, you are recognized. Manana Sidzuos.
Manana Sidzuos and Sidzuos Masi, Madam Speaker. I move to place Bill Number 248-36COR as amended by the Committee on Health, Land, Justice, and Culture into the third reading file, and I would like to discuss it.
Please proceed.
Bill Number 248-36 is an act to amend Section 81109, renumber Section 81112 as 81113, and add a new 81112 of Chapter 81, Title 10, Guam Code Annotated, and to add a new 20113 to Chapter 20 of Division 3, Title 26, Guam Administrative Rules and Regs, attached as Exhibit A, relative to authorizing the Commission on Postmortem Examinations to create a fee schedule for services and establishing the, quote, Office of Postmortem Examinations Operations Revolving Fund, unquote. The Commission on Postmortem Examinations, through its chairperson, Attorney General Levin Camacho, sent a letter to me as the chairperson on health requesting that the legislation be introduced to establish a special fund for the Office of Postmortem Examinations, OCME, and to allow the OCME to charge fees for its services. In that same letter, the Commission also requested adoption of a fee schedule for body storage, morgue processing, human body transport, autopsy and non-autopsy reports, certification or verification and other written instruments, and in-house photocopies. I introduced Bill 248-36COR pursuant to the request made by the Commission to authorize the Office of the Postmortem Examinations to impose fees and establish a special fund so that any adopted fees will go to the OCME for its operations. When we introduced this bill, the Commission was still trying to fill the Chief Medical Examiner position that had been vacant since 2019. The Commission has noted that it has been difficult to fill the position because the salary and compensation package is not as competitive as in other jurisdictions. Hopefully, this bill would give the Commission another tool to assist in securing a full-time medical examiner. The Commission, in their most recent meeting, has stated that previous candidate for the position is interested again in obtaining the position. He previously had familial constraints that caused him to withdraw his acceptance, but there may be a possibility that he may be offered the position again by the Commission. According to the AG's office, in the absence of a permanent medical examiner for Guam, the Postmortem Commission has ensured the continuity of service, quote, thanks to the Office of the Chief Medical Examiner's dedicated staff, most notably Ms. Johanna Bamba, and through contracts with both Dr. Philip Dalderman of the Commonwealth of the Northern Mariana Islands and Hawaii forensic pathologists, unquote. So Bill Number 248 excludes the initial fees requested by the Commission, but authorizes the Commission to proceed with establishing a fee schedule pursuant to the Administrative Adjudication Act, which will allow it to have its own public hearings on any fee proposals. The bill will not establish the actual fees, but will allow those fees after they have gone through the full AAA process, which requires the Commission to hold public hearings, obtain an economic impact statement, and get approval from the Governor and the Attorney General. It will also then need to come to the Legislature for an additional public hearing. This is to ensure full transparency and give the community multiple opportunities to discuss any proposed fees. As you know, these imposed fees may have a significant impact on the people of Guam, simply because of the urgency of getting, I don't know a nice way to say this, but getting, their loved ones out of the morgues at the hospitals or the medical examiner's office and taking them to be treated and buried. So Bill Number 248-36 in Section 5 adds a new section to the Guam Administrative Rules and Regulations that is consistent with the changes being made to the Guam Code annotated in the bill. And this is done again at the request of the Commission and ensures that their authority to promulgate these specific rules and these specific fees will be enacted immediately once the bill's passed and becomes law. And all the Commission will need to do is go through the AAA process to adopt the actual fees, but the initial rules will already be in place once this bill passes. So I ask my colleagues for their support, Madam Speaker. Situs Masi.
Buen provecho, Madam Speaker, for your presentation on this motion. Anyone else wishing to speak on the main motion? Anyone else? I will just give you a moment's recess. Imina Chantai the Legislature and Guam is back from recess. Anyone else on the main motion at this time? Good.
Thank you for the recess, Madam Speaker. We're good. Thank you.
Thank you very much. If there's no one else wishing to speak, Senator Perez, I will allow you to speak. Good morning.
Good morning.
Please proceed.
So I think this is an important measure. I know this is a bill creating a special fund, but I think it's more than that. It's about making sure that that we have staffing in place and the services, more importantly, in place when our people need it. During the pandemic, we experienced such delays that we had to put off the funeral arrangements, and it's very it's an unnecessary burden on our people to make them wait. So I rise in support of this measure. Susan Masi.
Buen provecho, Senator Pierce. Anyone else wishing? Senator Frank Blas. Brother Frank, you may proceed.
Thank you, Madam Chair. Madam Speaker. Madam Speaker, I recognize the significance and somewhat the need for being able to establish some type of, I guess, regulation, if you will, or to affirm a employee's responsibility. And while the bill itself is to affirm or to acknowledge the administrative rules and regulations and provides for this commission to be able to impose fees, I guess my question here is, and it's not so much to the author, it's just some question that I have to deal with it with myself, is, first off, many of the processes that occur in, the untimely passing of an individual required by law to be able to do certain things. Through certain aspects, these services are paid for already. And now while I acknowledge and I recognize this legislation doesn't set a fee, but it allows for a reasonable fee to be considered. And, in my mind is this now additional fee going to be a part of, or is it's going to be on top of what is already being paid for by tax dollars? Okay, so I'm going to take a little bit more time to be able to digest this, and it is my hope that if this does get promulgated, that when in the commission's work, that it sees, or that the necessity to impose the fees, that it does not become overburdensome for many of our grieving families. So again, while I rise in support of the establishment of the rules and regulations, I caution and I'm a little leery about the additional fees that may be imposed. Thank you very much, Manager.
You're very welcome, Senator Blas. Anyone else on the main motion? If not, Speaker Chalayi, you may close.
Thank you. Thank you, Madam Speaker, and to my colleagues. Excellent points, I think, were brought up, and that is there's a fine line between fees to cover the costs of these agencies versus overburdening the people of Guam, and whether we are able through appropriation to cover the costs of these agencies or not. And so this was discussed at the public hearing. We were told by members of the postmortem, or the Commission on Postmortem Examinations, which includes the Attorney General, Guam Memorial Hospital, and the Director of Public Health, and I think the Chief of Police, that these are done in other jurisdictions and that these are necessary for Guam. But that is one of the reasons why we've required them to go through the AAA process in its entirety, is because we are trying to make sure that the people of Guam are going to be able to weigh in, that all the current funeral homes are also able to thoroughly review these fees and see if they are able to suggest reductions in them for any reason. Some of these services we are subsidizing right now through the Guam Fire Department and other agencies such as transport. And so again, I'm just going to specify the fees that they are requesting to set in place are for body storage, morgue processing, human body transport, reports, verifications, certifications, and other documents, and of course photocopying. They've also told us that, so I've reviewed their budget, so for the last 3 years, their budget has remained the same. It's about $432,000. The chief medical examiner that they are looking to hire, they have offered him a salary of, well, they formerly offered him a salary of $310,000 plus benefits. I don't know the cost of those benefits. So, but they have testified that this, if fees are passed in the rates that they originally proposed, that would bring in from $80,000 to $100,000 a year, in addition to their $423,000 appropriation. So I'm just offering that to the body for their consideration. And the thing about this bill is that it authorizes them to establish fees. It authorizes them to defend these fees as to why they are reasonable, why they are necessary, and the economic impact statement will be accompanying those fees, and there will be a public hearing on those specific fees, and then again, the legislature will be reviewing those fees in the end. So again, I ask my colleagues for their consideration of this bill and support. Sitos Masi, Madam Speaker.
Speaker, on the motion to place into the voting file, please.
So I repeat my motion to place bill number 248-36 COR as amended by the Committee on Health, Land, Justice, and Culture into the third reading file.
On that motion, are there any objections? Seeing or hearing none, motion carries. Colleagues, we are now on Bill 262-36 LS as introduced by Vice Speaker Tina Rose Muñoz-Barnes.
On bill number 262-36 LS, Vice Speaker Tina Muñoz-Barnes, you are recognized.
Manana Sitos, Madam Speaker, and Sitos Masi, for giving me the opportunity to speak on Bill 262-36 LS. And I'd like to ask you, Madam Speaker, if we can move Bill number 262-36 LS as amended by the Committee on Health, Land, Justice, and Culture, as introduced by myself, Tina Rose Munya Barnes, and you speaker, Therese M. Terlai, which is an act to amend Section 18128 of Chapter 18, Title 10, Guam Code annotated relative to amending the requirements for a license to operate schools that teach cosmetology, barbering, manicuring, or nail technology, aesthetics, electrology, or hairstyling, and establishing an interim license for the schools seeking accreditation. I'd like to move it to the third reading, and if I can just briefly promise to speak on it.
Please proceed.
Situas Masitalu, Madam Speaker. Madam Speaker, this Bill 262-36 LS is a straightforward piece of legislation. It amends the licensure requirement for cosmetology schools to allow the Board of Barbering and Cosmetology to issue interim school licenses to schools in the process of getting accreditation. As the law currently stands, a cosmetology school can only be issued a license to operate if they are accredited by Western Association of Schools and Colleges or the National Accrediting Commission of Cosmetology Arts Sciences, also known as NACS, N-A-C-C-A-S. However, in order for cosmetology schools to achieve accreditations under the rules of NACS, they must have school license approved by the board. This, Madam Speaker and my colleagues, is a catch-22 within the existing statute. It prevents any new cosmetology school from opening and does not address what happens in the event a currently licensed school loses their accreditation. While the Board of Barbering and Cosmetology was able to issue an authorization for a new cosmetology school this year under the guidance of the Attorney General's Office of the Attorney General, as lawmakers, Madam Speaker, we have that responsibility to fix a problem currently in the books and develop a process for new cosmetology schools to open as they seek accreditation for a current cosmetology school to address issues of accreditation. It is important that we help Guam's current industry thrive, especially as we recover from this pandemic, Madam Speaker, and I want to share with my colleagues that there is a growing demand for cosmetology and barbering services, and we need to ensure that we have a qualified supply of barbers, cosmetologists, estheticians, and manicurists to meet the demand. I do, Madam Speaker, want to take the time to thank the Board of Barbering and Cosmetology for their input, and you, Madam Speaker, for working with me to update this bill to address the concerns from the stakeholders. So I ask for the support of my colleagues on this bill 262-36, and as I noted earlier, Madam Speaker, it literally is a need to fix what the existing catch-22. So thank you very much for giving me this opportunity, and I really hope my colleagues support our efforts in this. Sanamasi.
Sanamasi. On the bill, is there anyone else who'd like to be recognized? Senator Taitigui, you are recognized.
Situas Masi, Madam Speaker. I just have a question to the author of the legislation. As you know, when I attended the public hearing, there were quite a bit of people there to testify on the bill, providing their comments and concerns of the legislation. I do realize that the bill has been amended by the Committee on Health, and would like to ask what changes were made from the original bill to that was amended in this particular legislation that's before us.
Madam Speaker, you're recognized, or are you, do you yield to the question?
It's, no, actually, the author of the legislation, the question to the author.
Okay.
Yeah.
Madam Speaker, if I may, I'd like to yield, Madam Chair, to the committee chairperson on health as the amendments were made on the committee
Okay,
level.
thank you. Madam Speaker, do you yield to the question?
Yes, I do. So thank you for that question. One of the major changes that was made was based on a concern raised by Janice Uggan, the lead cosmetology instructor at the Guam Community College, of a potential loophole with the proposed language in the as introduced version, which would allow the school to apply as a new applicant should it fail to receive accreditation within 5 years. So she said that there would be nothing that prevents this 5-year perpetual cycle of interim school license from ceasing. So we tried to address that in the bill. Some of the changes that we made are, in the committee report, there is a markup version. We changed the title a little bit. We changed the words in 18128 on section 1. We took out the heading, and then we put on A2, where it used to say College or National Accrediting Commission of Cosmetology, Arts, and Sciences. We put the National Accrediting Commission of Career Arts and Sciences, or its successor, and that was based on testimony at the hearing. We also changed the language in section 2. If I'm reading this correctly, it looks like we deleted and changed the entire section to read the way it is now. Particularly, if you look on line 12, I think it is, it says the interim license shall be rescinded within 5 years after being issued an interim school license by the board. A school shall submit to the board proof that it has achieved accreditation. So it kind of ends it after 5 years and doesn't give them that repeating opportunity. And then requires the annual renewals. I hope that answers the questions, yeah.
Yeah, thank you so much. And I appreciate those changes because that were some of the concerns as well brought up during the public hearing. And, you know, I stand in support of this legislation. I think any bills that come before us to protect any kind of industry, you know, whether it's cosmetology or adoption agencies, we should have these rules and regulations in place and guidelines to follow. So I stand in support of this legislation. Thank you.
Thank you, Senator Tadigui. Are there any members wishing to speak on the bill? Senator Brown? Oh.
Thank you, Madam Speaker. If the sponsor would yield to a question, I just wanted to ask, because I also attended that public hearing, and I just wanted to inquire the standard period of time with regards to you know, a school being unaccredited, because 5 years is a long time, and I don't know if that's industry standard, because you're having a cosmetology school teaching their students, their clients, you know, what these processes and procedures are, and yet this could go on for like 7 years or more. So I'm kind of curious, is that the standard in the industry? Because how do we know that they are teaching them acceptable standards under the law if they're not accredited? And is there, you know, in this industry, is the accreditation required as we have for, you know, our schools and our colleges in the same way? Is accreditation required determining who sets those standards?
Would the sponsor yield to the question?
Madam Speaker, I will try to yield to that question, and based on the recommendations and the meetings that the Board of Cosmetology has here on Guam and working closely with the stakeholders in the community. That was the recommendation that was added. As far as it being the actual statute, based on the National Institute of Cosmetology, NIC, I know that each state has different provisions that are in place, but that was the recommendation to the body, to us.
Well, thank you. Thank you to the sponsor. I appreciate the response, but I know that was one of the concerns that was brought up, was whether or not even was the licensure required. This kind of accreditation, is it required, and who determines what those standards are? So I just think we need to be mindful of it because, you know, unfortunately, let's hope not. Let's hope we don't have unscrupulous individuals opening these type of schools that are, you know, training and not meeting the required, whatever those required. I'm sure there are. You know, as we talked with adoption rules and regulations that we would like to see those type of things in place for the safety and welfare of our people, and also for the students that are coming in and are being trained, you know, to make sure their investment and their time and effort with regards to that is going to meet the standards so that they can get licensed and go out there and perform the important work that they do, because, oh my goodness, where would we be without them? So I just want to note that, because 5 years is an awful long time to go unaccredited, even in this field. You know, I would be concerned about that, and I just think we need to be mindful. I'm hoping that those in the industry, perhaps this would be something to be monitored to see the progress should this bill, you know, pass the legislature and be signed into law, to see how that moves forward, because I don't know, I mean, do we have and maybe you can ask the sponsor another question, do we have an entity that comes out to Guam and evaluates to determine, you know, do they meet the standards of these institutions that are outlined in this bill, or are they here? How does that work? Because it's again, it's a little different area for me to be aware of here.
Does the sponsor yield?
Thank you very much. And again, Madam Speaker, based on us following a lot of the guidelines and provisions as noted by the National Institute of Cosmetology, nationally, those, Guam, I think, is a little bit more strict, but there are prerequisites through the NIC that Guam follows, and what we do is we take it from there. A mandatory 2 years requirement and documentation from the Training Institute is mandatory. And again, following the guidelines nationally, this is what the recommendations have come to us by. So I literally hope that that helps. And yes, the standards come from NASCAS.
Yes, I appreciate that. I understand that the standards, but who evaluates it? Do they have an accrediting team, like, you know, they come to evaluate the schools and colleges on Guam or the university? Or is it the local licensure board that we have that determines that accreditation? Who determines
Yes, Madam
those standards
Speaker.
just to
Thank you.
clarify?
Yes, Madam Speaker, based on that, there is a board, a full board of cosmetology that has been provided to the island of Guam through statute, and those and that board also works closely with the NIC, National Institute of Cosmetology, and in those efforts, that's why the provisions are very, very, very strict here on our island. So yes, the answer is yes, there is a board of cosmetology here. Yes, it has a full complement of the board of members, and yes, it meets regularly and
Okay.
gets updated all the time.
I won't belabor it. I thank the sponsor for elaborating. I just wanted to get the clarification. You know, does this accrediting team come from these national accrediting commission? Do they have do they have someone come out here and evaluate or determine whether or not these schools meet the standard, or is it our local accrediting board, you know, our local licensure board that does that? Hopefully we can get clarity. Lisa, hopefully I'll inquire further so I can get clarified. I just wanted clarification with regards to that. But thank you to the sponsor, and thank you, Madam Speaker, for the opportunity to ask these questions.
All right, thank you, Senator Brown. Are there any other members wishing to speak on the bill? Speaker Talahi, you're recognized.
Thank you. I rise in support of the bill. The public hearing, I thought, was very informational. They brought answers to almost all of these questions, and So it really is that Guam is setting a higher standard. We are requiring for schools accreditation within 5 years to be a school. And not everyone across the nation does that, or not every state, according to the testimony that we were given. And so we are allowing them 5 years, and that question was brought up at the hearing, and I believe it was the chairperson of the Guam Board of Barbering and Cosmetology who said that they found that reasonable and necessary because of the accreditation process, where sometimes they'll say something's not there, or you get into like she described it as an adjudicatory type of hearing where they're actually, she called it a lawsuit, but I think it's like a hearing that, you know, where they're challenging what you've produced, and that she's seen in their experience or across the nation that that's the kind of time it takes to get through that process. So that's, I think, was based on the accreditation teams and processes. One of the other requirements that I failed to mention earlier that was also added to the bill was that all documents submitted to the Western Association of Schools and Colleges or the National Accrediting Commission of Career Arts and Sciences or its successor for the purpose of accreditation also be submitted to the board. So the board's going to be able to see every document that was submitted for accreditation by these schools, and ensure that when they apply for licensing or renewal of license, that they are keeping up with what they've promised to do in their accreditation documents. It says also that, we've also added to the bill, that the board may rescind an interim license if a school fails to provide these documents. And what I like about the bill is that the board here on Guam is going to have to do their due diligence, whether a school is accredited or not. And pending accreditation, it's still going to have to review and give a temporary, or how do they say, an interim license, right, for these schools. And so this is like a new industry on Guam where they are trying to grow more schools, I believe. And this will hold them to a very high standard, and for those reasons, I am in support of the bill, and because it seemed to have the consensus within the barbering and cosmetology community. Si Diyos masi, Madam Speaker.
Thank you, Madam Speaker. Senator Torres, you're recognized.
Thank you, Madam Speaker. I also rise in full support of this bill. As the retiring speaker brought up, this brings it to a whole new level and actually makes barbering and cosmetology a lot more stringent. Although barbering, this doesn't address specifically barbering, it addresses cosmetology, but they oftentimes are woven into the same services and licenses. But as I recall, many years ago, the cosmetology profession was not as regulated. There weren't as many schools that were seeking accreditation, and accreditation in itself, the fact that we're now requiring it with this bill is setting a new standard, because most schools would only seek accreditation, as it was pointed out in the public hearing, would seek accreditation when they were interested in also aligning with Pell Grant eligibility. So accreditation was tied into that finance component. But ultimately, the students that go through these cosmetology schools, the end result is they could not practice unless they were licensed, and the licensing would then test the competency, not only the written competency knowledge, but also the practicum. So what I appreciate about this bill is it does bring us to a higher level, and it requires that everyone aspire for accreditation. But I think the most important component of this bill and why it needs to happen, as the author pointed out at the committee, at the public hearing, was that in order to seek accreditation, you must first have at least 2 years worth of a license, be licensed for 2 years. And so, as she pointed out, the main sponsor pointed out, it's a catch-22 situation, because how can you apply for accreditation when you don't first have a license, whether it's an interim license or a full license? So this then addresses that problem for schools that are seeking accreditation, is at least it gives them the interim license and the basis to then apply for accreditation. So I rise in full support, and I think that as we continue over the decades to ensure that the practice of cosmetology and barbering, cosmetology oftentimes involves chemicals that have to be safely administered, and it requires extreme hygiene and disinfection processes to prevent infections or injuries. It's important that we continue to elevate the standard of licensing, we elevate the standards for the schools, and that we know that anybody that falls into the hands of a barber or cosmetology that involves sharp instruments, that involves chemicals for the processing of hair, and sometimes skin treatments, that they also have higher standards. So I rise in full support, and I commend the author and co-sponsor for fixing what was a loop and a catch-22 as these schools aspired to accreditation and were barred in the past. Si Diyos masi.
Si Diyos masi, Senator. On the bill, is there anyone else like to be recognized on the bill? Senator Perez, you are recognized.
Thank you, Madam Speaker. I appreciate the dialogue by my colleagues and clarifying and giving context to the importance of this bill. I just do have a question regarding Section 3 of the bill. If a school loses accreditation, so just kind of to share with you my background as a medical technologist. We had to go through all the academic training as well as the practicums. And so just from my experience is that it's very important that, in order to practice and be licensed, one has to go to school at an accredited program. I mean, even with the Department of Education, if our schools become unaccredited, their credits don't matter anymore. As far as going to, it doesn't apply to, colleges, many colleges. So I just wanted to get maybe clarification on, the status of a student who's going to a school that does not have accreditation, and for a school that has his interim license, especially if a school has lost accreditation. So I think, the concern that I have is, what was the reasoning for the loss of the accreditation, and how does that translate to the student? Do they lack certain skills that really the public, depends or relies upon, and how is that being addressed, I guess, or how can that be addressed and for the interest of the public as well as for the student? Because, again, do they, should they move to the States? Are they marketable with this license from an interim licensed school? So those are just some of the things I would like to get clarification on. Thank you.
Would the sponsor yield to that question?
I'm going to try, Madam Speaker. If I understand the question correctly, my answer would be, the safe answer would be that the board can ask the school why they lost the accreditation is one, and I know that it would be up to the board to determine how would the process of the status come in. Given that, there are some reasons why they may lose accreditation. I'll probably throw an example. Most recently with the pandemic, some of them were in a financial hardship and could not follow through, so shop was closed. Madam Speaker, I will note for the record that there are now two schools, one's from the government, one's a private, and then the new one that's been given the authorization. There's a population of 170,000 here. And the need for this was that catch-22 was you needed the compiled data to get based on the national standard to get in. But how can you get the license if you can't even get the interim to come in because you can't open? And that's why the board brought it up to our attention. So the answer is yes, the board can. And the board can ask the school why they lost their accreditation, and the board, it is up to the board. Like I said, they could lose their accreditation because of finances, and the student can still get the license if the school is able to get the interim license based on the new ones coming in. So this industry, Madam Speaker, is and as far as the educational training, is very, very, very small. And of course, Guam, working with the national level, as we follow a lot of the protocols there, it is that who governs this area. Some have asked in the past to separate, but the board still felt compelled to follow the national standards and work with them. So I'm really hoping that that helps a little without me having to take a recess to seek with even the calling the Board of Cosmetology, but I think that should suffice. Thank you.
Senator Paris, you have the floor.
Okay, thank you for the response, and I guess there is that check with the board that can determine whether the school can get their interim license. I guess, so what does that mean for the student, right? So,
Madam Speaker, in a point of information, I do apologize to the good senator. I would also like to note for the record that each student who goes through this process knows that they have to go through a national test, both written examination and practicum. So that's another measure that's put in there. So you can't get it if you don't pass either. So I hope that helps.
thank you so much. That does answer the question. Thank you.
Thank you, Senator Paris. On the bill, is there anyone else who'd like to be recognized on the bill? If not, then the sponsor may close on the bill.
Madam Speaker, for giving me the opportunity to close, and I literally want to thank my colleagues who literally stood up with concerns and inquiries, but more importantly to voice their issues as it relates to this bill. As I noted earlier, Madam Speaker, with this industry being very critical and crucial to the community of Guam, you and I know that there are a lot of venues or establishments out there that have been in existence for many decades. But one thing's for sure, that the Board of Cosmetology has been really strict. And we've also heard concerns from the other sides, like they've put these protocols and these provisions in place, and it's really hard. But those are standards that have been provided as a guideline for us to make sure that the safety and the welfare of both the establishments and the customers are protected and safeguarded. So I just wanted to throw that also for the record, and again, thank everybody for their support and asking their questions. And at this time, Madam Speaker, if I may, I'd like to move this bill to the third reading voting file.
On the motion to move Bill number 262-36LS as amended by the Committee on Health, Land, Justice, and Culture to the third reading file. Is there any objection? Seeing no objection, motion carries. We're now on Bill number 292-36LS, sponsored by Talina Cruz Nelson. Senator Perez, you are recognized.
Thank you, Madam Speaker. I move to set aside Bill 292-36, sponsored by Senator Talina Cruz Nelson.
Thank you, Acting Majority Leader. On the motion to set aside the bill number 292-36 LS, is there any objection? Seeing no objection, motion carries. We're now on bill number 297-36 LS, as amended by the Committee on Environment, Revenue and Taxation, Labor, Procurement and Statistics, Research and Planning. Vice Speaker Tina Muñoz-Barnes, you are recognized.
Madam Speaker, if you may allow me just a moment's recess so I can get, I'm still waiting for one more documentation to come down. If you can just afford me a moment's recess, please.
All right, we'll take a 2-minute recess. We're back from recess. We're on Bill number 297-36 LS. Vice Speaker Tina Rose Munoz Barnes, you are recognized.
Situs Masi, Madam Speaker, again, for giving me the opportunity to speak on another bill. And this bill, Madam Speaker, is Bill number 297-36 LS, as amended by the Committee on the Environment, Revenue and Taxation, Labor, Procurement, and Statistics, Research, and Planning, as introduced by myself, Vice Speaker Tina Rose Munoz Barnes, my colleague Senator Mary Camacho Torres, Legislative Secretary Amanda L. Shelton, and Senator Jose Pito Terlai, which is an act to add a new Article 8 to Chapter 3 of Title 22 Guam Code annotated relative to eliminating discrimination and promoting women's health and economic security by ensuring reasonable workplace accommodations for workers whose ability to perform functions of a job are limited by pregnancy, childbirth, or a related medical condition, and cites this act as the Pregnancy Workers Fairness Act. I'd like to move it to the third reading, Madam Speaker, and if I can just speak, I'll try and be brief.
Take your time. Please proceed.
Thank you. Madam Speaker, no expectant mother should choose between her pregnancy and a paycheck. But for too many women, that is a choice they are forced to make. At present, there is no right under the Title VII of the Civil Rights Act of 1964 as amended by the 1978 Pregnancy Discrimination Act, the PDA, to workplace pregnancy accommodations. While there is some protection under the federal law, the PDA, the Americans with Disabilities Act, and the Americans with Disability Act Amendments Act of 2008 do not provide the legal protections necessary to ensure pregnant workers with known limitations can receive reasonable accommodations. This is apparent in how courts have determined the applicability of these laws in regards to pregnancy accommodations. In their 2015 decision in Young versus UPS, the U.S. Supreme Court held that when an employer accommodates non-pregnant workers who are temporarily limited in their ability to work, they cannot refuse to accommodate pregnant workers who make similar requests. However, this decision did not go far enough. The Young ruling does not guarantee a right to workplace accommodations for pregnant workers without this guarantee. Pregnant employees will continue to rely on having an understanding boss or being able to prove that the same accommodation had been granted before to the non-pregnant person. In seeking accommodations for pregnancy, childbirth, and related medical conditions, the ADA framework presents two major challenges. First, the ADA does not protect pregnant workers without complications, but who may require medically necessary accommodations to prevent disabilities from arising. In the Brown versus Area Health 2019, a Pennsylvania court determined that because an employee did not have pregnancy-related complications and a routine pregnancy is not considered a disability within the meaning of ADA, she had no rights to accommodations under the ADA-AA. Throughout the nation, states have found that the federal statute is lacking in their protection. In fact, Madam Speaker, 31 states have passed similar legislation to secure the right to these simple accommodations. The reality is that most women will be pregnant and employed at some point in their lives, and they deserve to feel supported and empowered to make decisions related to their pregnancy. If reasonable accommodations are not provided, such as help with heavy lifting or being provided a chair while on the clock, the health of the mother and pregnancy may be at risk, forcing workers to leave their jobs and unable to provide for their families. Bill 297-36 LS, also known as the Pregnant Workers Fairness Act, is a bipartisan effort to correct this injustice and to allow pregnant employees to continue working by ensuring that they can have these simple accommodations. My colleagues, additional bathroom breaks, light duty, or being afforded a chair to sit on are all reasonable requests at little to no cost to an employer, but they can make a difference for many pregnant employees. The Pregnant Workers Fairness Act expressly prohibits employment discrimination on the basis of pregnancy and pregnancy-related conditions. The Pregnancy Fairness Act would clarify that employers must make reasonable accommodations for workers affected by known limitation due to pregnancy, childbirth, or related medical conditions. Require an interactive process between the employers and pregnant workers to determine appropriate reasonable accommodations similar to the Americans with Disabilities Act. Protect the workers from retaliation, coercion, intimidation, threats, or interference if they request or use an accommodation, and provide an exemption for businesses if an accommodation imposes an undue hardship on employers. The Pregnancy Worker Fairness Act sets a clear standard for businesses to provide a temporary job modification needed to maintain a healthy pregnancy, absent undue hardships on employers. This ensures that all pregnant and postpartum workers have an access to simple but vital accommodations they need without jumping through legal hoops or risking losing their jobs. Worker health and safety is non-negotiable, and we need to make it a priority for everyone, especially our expectant and new mothers. And I know I have 8 minutes left, Madam Speaker, and if I may, some may say, you know what, based on everything I just said, that there's still the ADA and all these other acts and these statutes that were in place, right, that were already went to court. But here on Guam alone, when this issue came to me and I was working closely with our committee, I could not believe the number of employers who what we think is common sense was not common sense to them. And Madam Speaker, when I had several women call my office and tell me that, thank God we're finally doing this, and that someone was listening, I didn't realize the seriousness and the criticalness of what even simple accommodations that we think should be afforded when someone's pregnant, were not afforded. And it was even brought to my attention that some of the employers were saying, well, you know, we don't have time for that. Madam Speaker, that's really scary. Because you know what? We know on this earth, at least on this island, right, there should be courtesies of respect, right? Especially when someone is with child. You would think that, you know, all those respectful accommodations are being provided. But we, here on this island of Guam, having already cases that have been through the judicial system, it just has some of us wonder. So I really, Madam Speaker, want to thank my colleagues who helped supported the effort and probably hurt some of the pleas and cries for some of the women out there, even the women who had to file. So I humbly, Madam Speaker, ask my colleagues in this august body to look at this measure and really unanimously support these simple accommodations. And 99%, okay, I'll say 90, maybe, probably won't even cost a dime. So thank you, Madam Speaker, for giving me the opportunity to speak in support of this Bill 297-36 as I presented it. And I literally hope my colleagues will support that efforts with little controversy. So thank you, Madam Speaker. Sana Masi.
Sana Maasi. On the bill, anyone like to be recognized on the bill? Senator Brown, you're recognized on the bill.
Thank you. I did attend the public hearing, and I certainly understand the point of what the sponsor of this bill is trying to do. I just want to know, because it was brought up about how do you define that, and I don't know if, since that hearing, the issue, because it was also brought up by the representative of the Department of Labor, to be consistent with the federal law and how we implement this so that it doesn't become a point of contention. So I just want to get that clarified, because I mean, at one end, of course, we want equality, if not, and some argue, some areas we might be superior. But I want to point out, Madam Speaker, we had a colleague in one legislature that introduced a bill that would prohibit, or at least not require, pregnant women to sit on juries. And I'll tell you, the female members of the legislature, told that colleague exactly where to take that bill, because we thought, what are you inferring, that we're not rational enough to sit in a jury because we're pregnant? So, I understand the point. It depends on what type of job you're in. If you, for example, your job requires you to stand for 8 hours, that might be, a considerable hardship. If you were pregnant and you're in your 8th or 9th month, that would be considered a hardship. But I'm looking at the definition to see how do we really define that? Because at the other end, this can have the opposite effect, even though we're saying, oh, it would be illegal to discriminate against an employee who's pregnant. But, imagine an employer thinking, gosh, I got to meet all these requirements. Maybe they just never hire that person in the first place, and there's no evidence of that. There's no evidence for you to challenge that. They can say there are other reasons they didn't hire that person to get around it. So, I understand the point. I really do, but I just want to make sure we're not opening ourselves up, or we're not defining exactly what that means, because the Department of Labor was pretty persistent and consistent in relaying those concerns, that's properly defined, because this can be open-ended. And again, the unfortunate thing in this hearings we did not have, and I don't know if, employers, because we're assuming the government, so much of what we do here is all related to the government of Guam, as if that's the only thing that exists in this community. But we didn't have, members of the private sector in any number of significance present to even testify of, having questions or concerns, or were they even aware of this legislation, what this would have in their ability to execute it within their workplace. Because certainly if you're an employer, you're going to want to, you would think you would not need legislation like this, that you'd have common sense to want to assist your employee regardless of what their limitation might be. Some of it may be temporary because of a pregnancy, others might be long-term disability. But I'm reading this and I still don't know that this is properly defined. What we look at as accommodations, reasonable, what does that mean? We're talking about the facilities, and we're talking about the work schedule. I can modify my work schedule, I can get a part-time schedule, I can get a reassignment. I don't know, that doesn't see that definition addresses the concerns that were raised at the public hearing. I don't know if the sponsor wants to elaborate, if there's something more that's been added to this language that I don't see.
Would the sponsor yield to that question?
Again, Madam Speaker, I'm going to try. And I'm going to share with you that first, I guess to answer her thing, Guam Department of Labor has reviewed the updated bill, and they concur that they address the technical concerns they had. They also appreciate that the fines will be deposited into the Manpower Development Fund on that. But if I go back, Madam Speaker, and let me see where I'm at right now. I guess, Madam Speaker, this is what my train of thought is, that it should not be on the pregnant employee to have the burden of proof, one. As an example, in a 2019, a court determined that a cashier who was denied a stool to sit on while pregnant did not offer evidence that the employer granted similar accommodations to another employee who had difficulty standing for an extended periods of time, but refused her the same accommodation based on her pregnancy. In order to get accommodations, that employee needs to prove that there are coworkers at the job who have received similar accommodations. There are no federal laws specific to this, and like I said earlier, people tend to try and use the ADA for their protection. However, I want to state for the record, Madam Speaker, that the ADA does not cover for pregnancy accommodations. And I would also be remiss if I didn't note that much of the issue in the states have been played out in courts also. And I can read again in Young versus UPS 2015, the U.S. Supreme Court held that a pregnant employer carries the initial burden of establishing the fact that they face disparate treatment from their employer based on the framework established in McDonnell-Douglas Core versus Green in 1973. In the application of the PDA, the McDonnell-Douglas framework would require an employee to demonstrate that they belong to a protected class, that they sought and that were denied accommodations, and that the employer accommodated others similar to in their ability or inability to work. So, however, the standard has proven difficult for many pregnant employees to meet. The courts held employers were permitted to deny pregnant workers accommodations under the PDA in over 2/3 of post-young pregnancy accommodation cases, and in many instances it was because the pregnant employee failed to identify co-workers who were offered similar accommodations. The standard set in Young versus UPS places a unique burden of proof on the pregnant workers when other workers, such as those with disabilities, are legally entitled to reasonable accommodations and do not share the same burden. Under the ADAA, people with disabilities are entitled to reasonable accommodations by simply requesting one, unless the employer can demonstrate that such accommodations would impose undue hardship. And again, Madam Speaker, as this is being played out, even in our court system here today, this is why this issue from a bunch of women who have gone through the suffering have come and asked. And that's why I bring this up. So a pregnant woman should not have to prove. We believe that it should be accommodated. And common sense says that we, even culturally, should support those efforts, but those are not being done. And even after working with Department of Labor and getting the updates, this is what we've come up with. And I want to say, Madam Speaker, that, I hope that answers some of the inquiry, and I hope that I get that support, because this has been really grueling for some of our women here on the island. I'm not going to say many, I'm going to say some, because these are the some and others who've shared but don't have the money to go to court to prove themselves, when culturally and based on what we have today, it should be afforded, but it's not. I remember a speaker saying one day, a former speaker of ours saying, that we shouldn't have to legislate common sense, but sometimes we have to do it so that we can make that statement perfectly clear. And this is one of those cases, Madam Speaker. So thank you, and I thank the good speaker on this motion, at least inquiring, and I hope that helps in some of the efforts. Sanamasi.
Thank you,
Zaina
Madam
Masi.
Speaker, to the
Senator
sponsor of the
Brown.
bill for responding. I guess I just wanted that clarification, because that was obviously brought up by the Department of Labor. I mean, I would hope there are employers that are responsible. I mean, I myself have never had an issue with this during my time. I've not been approached by other women, and my goodness, I know many who have all been mothers and who have all, done more work than me and have many more children than I have had. And certainly, I think we'd want to see those cases covered, but I just want consistency in that, because I also don't want the reverse, and it does happen. It's the reality that does happen. that some may abuse or take advantage of it. And I guess that's something that will have to take its course in the process. I mean, we want to make sure people are, in a safe, healthy work environment. I mean, pregnant or not, I think after 8 hours I'd want a stool to sit on as well. I think most people would. But it's also the nature of the work, and I don't know legally how they're going to address that depending on what type of work you're doing. How that's going to be affected as to whether or not, what if someone's not able to perform their job at all because of their health circumstance at that moment? Do they take leave? I mean, I assume those procedures are already in place, and maybe this is another layer. I just want to make sure there's fairness in the process because, again, I do want to note, colleagues, that if we do vote on this bill, I did not hear at the public hearing, or I've not seen testimony even submitted since then from employers on Guam with regards to their view on this or what impact this would have, or do they feel it's going to put any additional undue burden? Again, I assume it's going to be dependent on the type of work that's performed and what's required. I mean, you want to make sure people are properly and respectfully treated. But again, I don't want to continue to add layers and layers and layers and layers as well if there's any issue with regards to implementing it and making it difficult for people to even hire people to perform jobs. I think we always have to ensure there's a balance and a clear view of what the mission is without people being taken advantage of, certainly. So I appreciate the response to my questions. Thank you.
Thank you, Senator. On the bill, is there anyone else who would like to be recognized on the bill? Senator Perez, you are recognized.
Yeah, just a point of information. We did reach out, so after the public hearing, we wanted to address the concerns from the Department of Labor, and so we did reach out to them as well as SHRM to get their input on the bill. So there was we did look at it, and they pointed out parts of the bill that were problematic to implement. In addition, we looked at the committee reports for the congressional bill. There's a similar congressional bill, and we made sure that we addressed those concerns. So that's what you see today has been vetted. And just assurances by the Department of Labor, they work in close collaboration with the federal government. So they said that when they're looking at each individual complaint, they would have to look at it from a case-by-case basis. And so this is something that they're confident that with the verbiage in the bill, they're confident that they can work with the language in the bill. So they do work closely with the Job Accommodations Network, or JAN, which is under the U.S. Department of Labor, Office of Disability Employment Policy. So they get a lot of their guidance through them. And so in talking with SHRM too, they said that this is pretty much the norm in a lot of the businesses, and there wasn't any issues raised in regards to which employers. So right now the bill says that there are 15. This bill would apply to businesses with 15 or more employees. And that's what is stated in federal, for the federal government. And so we basically utilize what was currently the norm in employment or employers. Situas Masi.
Situas Masi, Senator. On the bill, Senator Torres, you are recognized.
Thank you, Madam Chair. I also wanted to, just following on the retiring speaker, one of the amendments that was made that I think addressed a lot of what Department of Labor had reservations about were made on Section 3803, non-discrimination with regard to reasonable accommodations related to pregnancy. And the amendment that was made there following the public hearing was to strike the words "or related medical conditions." And that sort of narrowed it down to, the concern was how do we ascertain whether the conditions with this woman, a pregnant woman, are related specifically to her pregnancy, her state of pregnancy, or are they related to other conditions that are not necessarily brought on by pregnancy. So that one amendment alone, I think, covered a lot of the concerns about, are we overreaching, or are we specific to making reasonable accommodations to known limitations that are related to pregnancy? And I believe that the bill as amended is specific to reasonable accommodations to known limitations related to pregnancy. And in that regard, it is a sensible and measure that just adds another protection to women. And when we think about it, as the sponsor mentioned in the committee at the public hearing, sometimes something as simple as accommodating an appointment schedule, where an appointment with your physician can't be, your OBGYN, can't happen before 8 o'clock or after 5 o'clock. Making those reasonable considerations. As appointments are monthly, sometimes more frequent for women who have complications. So it's those sorts of things. Something as reasonable as more frequent bathroom breaks, which pregnant women have because of their condition and the compression of their organs, they would be more likely to frequent the restroom than someone who didn't have their organs compressed by a growing uterus and fetus and baby. So with that, it does make sense, and I think that the way that it was amended addressed a lot of those concerns that were raised not only in the submission of the testimony, but also in discussion at the public hearing. So I stand in full support, and I just commend the authors for being reasonable at finding a balance with Department of Labor and also with employers who have more than 15 employees in their agencies or businesses. Sidus Masi.
Sidus Masi. On the bill, Senator Rangel, you are recognized on the bill.
Thank you, Madam Speaker. I rise in support of the measure. I think we should do anything we can to help protect women, especially women who are pregnant while they're working. Something very complicated, something I will never personally understand what they're going through, but my wife was recently pregnant while she was working. Fortunately for my wife and I, she was with an employer who was very receptive to making whatever reasonable, as the term is used, reasonable accommodations for my wife while she was pregnant. However, I often thought what would happen if she did not have an employer who was that reasonable and able to make those reasonable accommodations throughout my wife's pregnancy. If she didn't have that type of employer, then there may have been a lot of problems with her employment. She may have had to quit her job, as a matter of fact. So I think anything we can do to protect women who are pregnant and ensure that the employers are making reasonable accommodations is something that we should definitely support. So with that, Madam Speaker, I rise in full support of the measure. Thank you.
Thank you, Senator. On the bill. Anyone else on the bill? If not, then the sponsor may close on the bill.
Undunklen Sidus Masi, Madam Speaker, and again, I want to extend my thank yous to my colleagues who spoke on the measure, who shared their presentations, but more importantly, even their inquiries, because it does give us more information on what is happening today. So I want to thank all of them, but also, Madam Speaker, I literally hope that I can get a unanimous support on this, and at this time I'd like to move this bill into the third reading voting file.
On that motion, is there any objection? Seeing no objection, motion carries.
High cup. Hey, colleagues, it's a little bit after 11, but we're going to try and push in one more bill, and I'm going to go ahead and recognize Speaker Therese Terlai on Bill 319-36CR. Speaker, you may proceed.
Thank you very much, and I'm very happy to proceed following the bill that just passed. to third reading, Madam Speaker. So I would like to make a motion to place Bill number 319-36 COR as amended by the prime sponsor and further amended by the Committee on Health, Land, Justice, and Culture, sponsored by Therese M. Terlahi and Tello T. Taitukwi, which is an act to add a new Chapter 42C to Division 3 of Title 7, Guam Code Annotated, relative to enacting the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021 into Guam law. And I'd like to speak on that motion, Madam Speaker.
Speaker Therese, please, I allow you to speak on the main motion.
Thank you. On March 3rd, 2022, the United States Congress enacted Public Law 117-90, also known as the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021, effectively invalidating any pre-dispute arbitration clause in cases involving sexual misconduct allegations. This major piece of legislation was championed and supported by a mass coalition of survivors of sexual harassment and sexual assault, and their allies, to include the National Center on Domestic and Sexual Violence, the National Coalition Against Domestic Violence, the National Domestic Violence Hotline, the National Network to End Domestic Violence, Public Citizen, and the American Association of Justice, amongst many, many more. The Ending Forced Arbitration Act was inserted within the Federal Arbitration Act, which is found in Title IX of the United States Code, Chapter 1. Thus, the Act only governs if the FAA governs. And as some of you may know, the FAA is the Federal Arbitration Act. And some of you may know that Guam did not adopt the Federal Arbitration Act and instead implemented its own arbitration procedures in Title VII of the Guam Code Annotated. And while courts have found that the FAA applies to the U.S. states, we have not found a definition of states in the FAA to include Guam, as it does in other federal statutes, such as the Uniform Child Custody Jurisdiction Act and others. So it's the intent of Bill 319-36, as amended, to ensure that the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021 will also apply to Guam. Madam Speaker, it must be the most unbearable thing to be sexually harassed or assaulted by an employer, a colleague, a medical professional, and then be forced to settle your disputes in secretive proceedings in a private system. And we know that here on Guam, a person harassed or assaulted in incidences by a doctor cannot go straight to court for a civil action and must proceed under the mandatory medical practice arbitration law, where fees range upwards of $50,000. In that case, that person may also file a complaint with the Medical Licensing Board. But as we have seen through our oversight of these boards, many cases with these exact allegations are still pending after 4 years. A survivor can also file a claim with the Office of the Attorney General, but it will be up to the Attorney General's office to pursue that criminal claim, which can take up to 2 years. We have seen and witnessed these realities during this term. The New York Times describes the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act as a bill that would, for the first time, ensure that victims of sexual harassment and assault have the option of suing their abusers in court, invalidating any contract that closed off that option, a common condition of employment at many companies. Nancy Erica Smith is an employment lawyer who represented Gretchen Carlson, the former Fox News host, in her landmark sexual harassment case against Mr. Ailes, the former chief executive of Fox News. And she was quoted as saying, "The Weinsteins, the Cosbys, the Roger Ailes, and the Bill O'Reillys of the world used mandatory arbitration to force women into secrecy. They stayed in positions of power and continued to abuse women. The New York Times goes on throughout this article to say that forced arbitration often requires employees who bring an accusation of workplace misconduct to enter a private proceeding with their employer. It takes away employees' rights to make those claims public in court, shifting them to a process that takes place in secret, led by company-appointed arbitrators, and without the ability to appeal the result. Lawmakers said that the process weighed heavily in favor of protecting predators and against victims. The legislation seeks to give victims a choice in how they report their claims, including the option to do so publicly. In an interview with Representative Sherry Bustos, Democrat of Illinois, a co-sponsor of the House legislation, she called the move to change that practice across the board, quote, the most significant labor legislation of this century. Proponents of the bill argued that the measure was vital not only to give victims of sexual assault or harassment the option of a public airing of their allegations, but to signal to businesses that they too are at legal risk when such cases occur in their workplace. Going to court is not easy, but the threat of women going to court often makes companies take a realistic view of their liability. When a woman files a sexual harassment lawsuit in court, she typically ends up hearing from other women, and that doesn't happen when you file a request for arbitration. It's a much bigger threat to be able to go to court. So, Madam Speaker, I hope that the bill, as simple as on its face, that this is going to make Guam consistent with what the United States has passed to be implemented across the nation, and that is that clauses that mandate arbitration for sexual harassment or misconduct, sexual misconduct cases are no longer going to will now be allowed to where the person who is affected will have choice, Madam Speaker, will have the ability to pursue those cases in other venues. So I ask my colleagues for their support of this bill. Situs Masi.
Thank you very much, Speaker Chirlahi. I'll go ahead and address Senator Taitigui now on the main motion.
Situs Masi, Madam Speaker. Madam Speaker, I'd like to thank Madam Speaker Chirlahi for allowing me to be a part of this legislation. And I'm very grateful because it's things that we've been working on. And moving forward, as she mentioned, U.S. Public Law 117-90, ending forced arbitration of sexual assault and sexual harassment Act of 2020 prohibits the enforcement of mandatory arbitration on sexual assault and sexual harassment cases. The Ending of Forced Arbitration Act is one of the most significant changes to employment law in years. This part situates the new law against the backdrop of the forced arbitration controversy. Within the last several decades, forced arbitration has become common, buried deep within the fine print of employment and consultant contracts. Forced arbitration lacks transparency, and it does not guarantee the relevant law will be applied to these disputes, resulting in fairness and equity in the process. Arbitration's secretive nature is often shielded from public scrutiny, forcing settlement in disputes against companies in arbitrations favoring in companies. Ending forced arbitration for sexual assault and sexual harassment is supported by a coalition, many groups that the speaker had mentioned. So I ask this body as well to add your name to those individuals who also support this legislation. and that is the National Coalition Against Domestic Violence, the National Domestic Violence Hotline, the National Network and End Domestic Violence, and RAINN, R-I-N-N, the Sexual Violence Prevention Association, and the Public Citizens and the Americans Against Association of Justice. Let's be a part of that group, a group that works very hard to protect our rights. So thank you, Madam Speaker, for the opportunity.
You're very welcome, Senator Tadegui. Anyone else on the main motion? If not, Speaker Chalayi, you may close.
Thank you, Madam Speaker. I'd like to ask if, or make a motion that Legislative Council be allowed to make change to the title and throughout the bill to the term Act of 2021, if that should be changed to 2022 for
Thank
her
you.
to consider and make that decision.
On that motion, are there any objections for the technical change? Seeing none, motion carries. Speaker Chalayi.
Thank you, Madam Speaker. And so, in closing, I'm just going to say that forced arbitration strips a survivor, an affected person, of the right to decide how to pursue accountability and does very little to stop this type of systemic abuse from occurring again. We have heard of stories from survivors right here on our island for whom forced arbitration continues to place barriers in front of their quest for justice. And my colleagues, I urge you to join the rest of the nation, and let's help break those barriers in any way that we can. Situ Smasi.
On the motion to the third reading voting file, are there any objections? Seeing or hearing none, motion carries. Senator Paris on a motion to, I'm sorry. Majority Leader, I'll recognize you at this time.
Thank you, Madam Vice Speaker. I'd like to make a motion that we recess till 3 p.m.
3?
Yes.
On that motion, without objection, motion carries. Thank you very much. We are in recess to 3 p.m. this afternoon.